The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. Our next case is State versus Betts, and I will note that Justice Berger is recused in this case. That being said, we'll hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Craig Cooley. I represent Ervan Betts in this matter. And if you can't hear me, I'm in a different country. I'm in Toronto, Canada. So hopefully I've done a couple virtual hearings over the last couple months and they've been successful. So hopefully we can get through this unscathed. But if you can't hear me, just wave your hand and I will try to rectify that. We're here before the court regarding a case from the Court of Appeals that resulted in a lengthy dissent from Judge Tyson. It concerns 3 counts of indecent liberties regarding MC, a 7-year-old from Forsyth County. And it's an interesting case because there's multiple issues we can discuss today. And I plan on discussing each in my own sequence, but if the court would like to discuss one, feel free. I'm game for any questions. But I'm going to start with the one claim that actually wasn't adjudicated before the Court of Appeals, which is the Catherine Massola claim. And it's a straightforward vouching claim. Again, this is a child sex case where it delayed, where the child didn't immediately report the allegations of sexual abuse. Thus, there was no physical evidence of sexual abuse ever mentioned. And before the Court of Appeals, I thought I presented it quite clearly that one of the claims I made for plain error was the fact that the way the prosecutor questioned Ms. Massola constituted improper vouching when she did a comprehensive Q&A with Ms. Massola regarding MC's PTSD diagnosis. So once MC made her allegations in October of 2013, she was then subsequently interviewed by a DDS worker on November 4th of 13, which resulted in a forensic interview on November 26th of 2013, and which ultimately resulted in Fulton McSwain, the forensic interviewer, suggesting that she seek counseling, and Catherine Massola was MC's counselor, therapist, what have you. And during these therapy sessions, MC created a trauma narrative, and throughout the course of this counseling, Ms. Massola diagnosed MC with post-traumatic stress disorder. And during the last part of Massola's testimony on direct appeal, there was a series of questions where the prosecutor was trying to flesh out what exactly is the basis of the PTSD diagnosis. And again, this would be on page 20 and 21 of my brief, opening the new brief. The prosecutor asked a series of questions the trial counsel objected to initially, and then on page 21, it gets into the challenged testimony where the prosecutor says, quote, and when you make a diagnosis of post-traumatic stress disorder, and there are several types of traumatic events that could lead to the diagnosis. Answer, yes. And would violence in the home be one of those? Answer, yes. And would domestic violence or witnessing domestic violence? Answer, yes, it's one of the questions. Questions. The question, what about sexual abuse? Answer, yes. And then here's the critical question that the prosecutor asked. Quote, would it be fair to say that MC had experienced a number of traumas? And Ms. Massola answered yes. And the question would be, that was based on your therapy? Yes. Based on that dialogue, Ms. Massola, it's our position, effectively diagnosed sexual abuse. told the jury. I mean, the jury's going to hear this from the child's therapist, who to her said that she had in fact experienced a number of traumas. And if you look at the testimony at trial, again, the state only presented 5 witnesses. You have MC, you have Archie Melody, you have Sergeant Pritchett, you have Fulton McSwain, the forensic interviewer, and then you have Catherine Masoli. And MC mentioned in her forensic interview and in her therapy different allegations of domestic violence she witnessed, where Mr. Betts allegedly did certain things to her mother, and she also mentioned these allegations of sexual inappropriate touching. And so the jury would have to understand, okay, the only evidence we heard was about the domestic violence and about the sexual abuse. And if the expert is asked, would it be fair to say that MC had experienced a number of traumas? The easy, reasonable inference is that Ms. Masoli believed, in fact, that she was, in fact, sexually abused. Now, in my briefing, this is called sleight of hand vouching. And you see it all the time in these types of cases, where the expert and the prosecutor, I believe, most experts in these types of cases know they can't walk in the court and say, you know what, jurors, I believe this child was sexually abused by the defendant, even though there's no physical evidence. Most experienced forensic interviewers and social workers who work with children who have claimed sexual abuse know that. And so the question is, how do you convey to the jury that this person believes that without explicitly saying it? And this is just another example. Would it be fair to say that MC had experienced a number of traumas? Yes, she had. And then on page 77 of the transcripts of volume 4, the prosecutor asked basically a closing question, and Masoli says, quote, it's kind of what it sounds like. She had multiple different kinds of trauma that just kind of built on each other. Sometimes it's part of the process than if it's just like one particular trauma, like domestic violence or sexual abuse. So with the vouching question, the first, I think, issue the court has to answer is, does this constitute impermissible vouching? I believe it does, because the way in which it was presented would lead jurors to believe, and again, this whole case is about words and semantics in trials, because of the second claim, the disclosure claim, is the same thing. Jurors understand, right, what each witness is saying. They understand the roles of each witness. And here you have the child's therapist saying to them, yeah, she in fact had experienced these things. And so it's Mr. Betts' position and my position that in fact constitutes impermissible vouching. Now, I don't know why the COA did not roll on the claim. I have no idea why. And Judge Tyson didn't address it either. So I'm at a loss for why that wasn't addressed. And if you look at my Court of Appeals brief, I pretty made it clear that this is a claim. And like in the state's reply brief, they claim I waived it. There's no waiver, right? Because if you look at the Court of Appeals arguments or briefs from the states, the state's primary argument is like, Mr. Coley didn't cite enough cases, so it must lack merit. They didn't mention waiver at all to the Court of Appeals. And the sole argument was like, oh, there's no case law, so it must be meritless. So they took a substantive approach to the claim. They didn't make a procedural argument saying the lack of case law prevented the court from ruling.
Let me ask about your vouching
Sure.
position in light of this series of questions and answers that you cite on pages 20 and 21 of your brief.
Sure.
The counsel had intertwined questions about domestic violence with matters of the sexual abuse that was alleged. Are you saying that the vouching would have been towards the sexual abuse alone? And how do you otherwise narrow it to that kind of vouching when there were questions about domestic violence as well?
I think it was for both, Justice Morgan. I think it went, if you, a reasonable juror hearing this testimony would walk away saying, MC testified about two things: domestic violence, witnessing domestic violence, and these allegations that Ervan Betts touched her inappropriately. Right? And the prosecutor geared those questions regarding those two particular topics: domestic violence. She didn't talk about bullying in school. She didn't talk about mom being on drugs. All these different types of trauma that could impact a child, the prosecutor never asked about, right? I mean, if you look at the sole reason the DDS worker went back to interview her the second time was not because of her initial quasi allegation the first time the DDS worker went there. The second time the DDS worker went there was because her mom tested positive yet again for drugs, and they went there to question her about that. So again, there are many things in this child's life, it sounds like, that could have impacted the child in a traumatic manner.
But in the context in which these questions were asked, and again, this is just an excerpt of a number of matters about which the expert was asked, how do you feel as though this court should look at this particular area of her testimony as being vouching, and on top of that, the jury isolating the vouching to assume what you're saying for the purposes of your position here being towards the sexual abuse that's alleged?
I think, Justice Morgan, I think two cases in particular will give an idea of how I perceive the argument. One is this court's opinion in Tao, T-O-W, and then one is from a case this court is an opinion this court issued, I believe, on December 18th in State versus Williams, which, let me get the site here. It's another child sex case. State versus Williams is 852 Southeast 2nd 184. And I'll talk about Tao first. Tao, if you look at the challenge testimony in Tao, the expert said this: roughly 70 to 75% of abused children don't show symptoms or medical evidence, medical symptoms of abuse. And then the prosecutor asked that expert, well, the accuser in this case, is she in that group? And the expert said, yes, she would be in that group of 70, 75% of children who are abused, who don't show symptoms. And the Court of Appeals and this court said that constituted impermissible vouching, even though she didn't explicitly say she diagnosed sexual abuse. That's what a reasonable juror would interpret that. Well, doctor said she was part of this group of abused children that don't present with medical symptoms. So she must have been abused, but there's just no medical symptoms. I think that's similar here. Again, Ms. Sola didn't explicitly vouch. Again, it's called sleight of hand vouching, where you ask the questions in an orchestrated way to get the desired inference you want from the jurors. And this is, I think, just as strong, if not stronger, where you're talking about two sets of traumas throughout trial, domestic violence and sexual abuse. And then you ask the child's therapist, well, did she experience these traumas? And you specifically—
How do we go about discerning what you depict as sleight of hand vouching if this is largely contextual?
Well, what would a reasonable juror interpret? Because there's, again, if you look at Tao and then you look at Williams was similar. In Williams, a DDS investigator who investigated the case testified, here's how we investigate cases. If we substantiate the case, we believe it. So if we believe it, we substantiate it. If we don't believe it, we don't substantiate it. So, and then the prosecutor, the next question was, well, what did you do in this case? Well, we substantiated it. Right? That the DDS worker did not explicitly say he believed it. He just said he substantiated it. But again, the decision-making, I think the majority in the state want to believe that decision-making in a jury trial is in a vacuum, and it's not. Right? There's only two traumas that were discussed throughout trial. domestic violence and sexual abuse.
Mr. Cooley,
And so,
let me interrupt you just a second. Are you arguing then that the testimony of Ms. Mazzola, or however you pronounce it in this case, is indistinguishable from the testimony? Did you substantiate the claim? Yes. Is it your argument those two are the same?
wait, can you repeat the question? What?
Yes, sir. We've got the testimony of Ms. Mazzola in this case that you've been talking about. Is it your argument that the testimony of Ms. Mazzola in this case is indistinguishable from on any meaningful basis from the testimony in the case that you just described?
In Williams and Tao?
Yes. And I mean, your argument is that this is no different than a situation in which the witness is asked, did you substantiate the abuse? Yes. The two are the same.
Yes, that's the shortest answer is yes. I believe that Tao and Williams really drive home that point. In both of those cases, neither of the experts explicitly went on the record and said, I believe the accuser. They just did it in a roundabout way. And that's why I just sleight of hand where the jurors are smart. They listen to the testimony, they listen to the facts, and they make decisions based on that. And this sequence of events, and based on what MC testified and everybody else testified, Fulton McSwain, Ms. Masoli, again, domestic violence, sexual abuse. At the end of the day, the juror is going to say, well, there's no physical evidence, but we have Fulton McSwain, which I'm not challenging Fulton McSwain's, but you have the two experts, particularly her therapist, who she spent a tremendous amount of time with, telling the jury that, you know what, yeah, she did in fact experience multiple traumas, and the prosecutor specifically fleshed out, like, could it be domestic violence? Could it be sexual abuse? And yet she chose not to mention any other potential trauma in this child's life that could have been the basis of that PTSD diagnosis. So yes, Your Honor, I would argue that Tao and Williams are very similar because there's the absence of explicit vouching.
Isn't it true that here the therapist specifically, when asked the most traumatic event, she said it's the most traumatic was the gun, and then she described that as when the defendant came to the house with a gun and tried to get in the house. She thought she was going to die. Didn't the focus appear to be on the domestic violence that actually occurred to this child, not observing domestic violence, not occurring to her mother, but this specific event that impacted her?
I would answer your question, multi-part question. Your first question is yes, there was a mention. Masoli did in fact testify that based on her counseling of MC, MC's statements to her, it sounds like MC thought that the gun incident was the one that most impacted her. That's true, but can we still, I guess my question would be, how does that nullify the fact that she also mentioned sexual abuse in there? I agree with you that she did put that on the record, but at the same time, the prosecutor also explicitly asked about, and what about sexual abuse? I mean, that's right before she asked, would it be fair to say MC had experienced a number of traumas? So I would agree with you that there is testimony consistent with what your question was, but I would disagree that simply saying that the gun incident was more traumatic somehow alleviates or minimizes the prejudice caused by this sequence of questioning. Somebody asked that?
Can I ask you to address the issue that was raised by the dissent on vouching, and that is the question of the use of the word disclosure?
Sure.
And it seems that is a term that is used almost, I mean, it's just all the time in this field. That a rule that somehow that's improper vouching would impact all of these cases pretty substantially.
No, I don't disagree with your Honor's statement. It's used over and over again, and I think the point of the argument is the question why. And again, this case is about language and semantics and trials. And look at our briefs. Look, I know Hayward didn't write the brief, but look at the state's opening brief compared to mine. They don't mention Ervan Bett's name. It's the defendant, the defendant, the defendant. How do I humanize him? It's the same thing. When we choose words, we do it for a specific reason. Like when I write a brief, I say alleged. The state alleged he did this. The state alleged he did that. Whereas the state is going to write, Mr. Betts, in fact, did this. So it's the same thing at trial when you use certain words, disclosure in particular. And look at, again, it's just jurors will understand it. And I've made this point in my brief, is that when you take what the state's witnesses were testifying to about like domestic violence and sexual abuse, and you take the principle that jurors understand and give effect to every word that's uttered by witnesses, I think that has to have value. And if you look at the word disclose, the question is, why are they using the same word over and over again? There's a reason for that, because they know what impact it has on jurors. It's like disclosure. Let's talk about Brady. A Brady disclosure is when there is in fact something in the possession of the state that was not quote unquote disclosed. So there is a fact there that wasn't disclosed. And again, when we have conversations with people, we never say, what did you disclose to Mrs. Smith, your neighbor? We don't do that. We don't talk like that. Like, what did you talked to your neighbor yesterday? What did she say? I never asked anybody, what did she disclose to you when you talked to her?
Does it make a difference that defense counsel at some point used the same term?
It would have, the state had raised that claim before the Court of Appeals. And I guess the answer would be, it depends. If I was trial counsel and I was raising the objection of saying, look, this is how it's being used, or if, in the other sense, if trial counsel did what the prosecutor did here, yeah, you would have basically an invited error argument. You can't have it both ways.
Didn't defense counsel actually use the term or derivation thereof at some point in questioning as well?
It was, the state used it close to 40 times, 36 times. I think the trial counsel used it maybe 3 or 4 times. Yes, there was instances, but I mean, my first argument would be, was that argument's waived. You could have raised that at the Court of Appeals and they didn't.
Well, my point is in terms of inherently saying that disclosure or disclose or disclosing or some derivation of the root word disclose, since you represent that in and of itself constitutes vouching, if it is used by both sides as a term that has no particular connotation, if both sides are using it, doesn't that somewhat negate the inference that it automatically goes towards vouching of a state's witness's position?
If trial counsel used it repeatedly, like the prosecutor did, yes, I would. You can't have it both ways. I would agree with you that if this court holds that from moving forward, we can no longer say disclose, and both trial counsel and the prosecutor use it, I can't claim argument. I mean, yes, I would agree with you. Here, I don't think that happened. He might have said it maybe 2 or 3 times. It wasn't that much, because I would be honest, if it was a lot, they would have pointed it out in their briefs before the Court of Appeals and made the waiver argument or the invited error argument. It just didn't happen at the extent. I mean, it happened, I have a breakdown. It happened 20 times with Fulton McSwain. It happened 4 times with Masoli. So, and they're 2 experts. There is a mention of disclosure. I mean, there's a whole dialogue of the disclosure process. And the visual that the jury gets about disclosure is there's something inherent, there's fact possessed in this child that she is somehow giving to the state. Right? So I don't know, like in a murder case, I don't know, when a witness gives a statement, they never talk about disclosure of that statement. But when it comes to a child, they have this great dialogue. And there's a reason for that, because in most of these cases, there's no physical evidence. And so for the state to meet its burden, they have to prove, like in this case, that the child's credible. And they will go to great lengths to do that. And this is just one of them. I mean, again, words have meaning. Again, I humanize Mr. Betts when I write my briefs because I want you, the court, when they roll on it, to realize that your ruling is going to have an impact on a human being, not a defendant or the appellant. It's the same thing at trial. When the state has no physical evidence and it's in MC's, I mean, Justice Tyson wrote 6 pages of inconsistencies in MC's allegations. So the whole case came down to credibility. And in these cases, that's all you have. And I've worked many of these cases, and you see it over and over again. There's a particular reason why they do it. And I agree. I've seen defense counsel do it too. And I try not to do it. But if defense counsel and the prosecutor use it over and over again, I would have never raised the claim. It would have been like, why? I can't have it. I'm talking out both sides of my mouth. I can't blame the prosecutor for doing it. And then like, oh, it's okay if the trial counsel does it. I'm not arguing that here. It's the quantity of times that it was said and the detail from the state's experts in describing this process that is somewhat unique to children, that they have these facts that you want to extract from them, and then they're providing it to the state. And so hopefully that's a long-winded answer to your question, but I'm going to say, anybody have any other questions? I was going to go ahead.
That aspect of your argument, the use of the word disclose, you've been talking about how many times the state used some variation of that word, but I understood your argument to be that it was the equivalent of vouching.
Yeah.
If it is straight up vouching, like they only have to say that, testify once that I believe that what she was saying was the truth. You don't have to analyze it in terms of how many times the witness actually vouched for the testimony for it to be error. Is that correct?
No, I would agree. No, I agree. It just, in this case, and again, Jameson was decided shortly before this case, and I read Jameson, and then when I read the transcripts, I'm like, wow, it sticks out in a lot of these cases. So this isn't the first case I've raised it. It's the first case that's gotten here on this issue, but I agree. I mean, if you're going to use the word disclose when describing what the child said or alleged or claimed or what she said to you, again, in my reply brief and my opening brief, there are many words that we use in everyday language that could explain what MC said. And again, just think about the typical conversations with the justices amongst themselves. Justice Newby, what did Justice Hudson disclose to you at lunch? I don't talk like that. We don't. No one talks like that.
Well, is the argument that it's vouching, or is it more similar to sort of a due process argument or something about the implication of the word?
I think it's vouching because a juror hearing that would say there's something there that it's just like get a visual of a Brady claim. There's facts in the state's possession that weren't disclosed. So there are actual facts. There's a factual basis. And if you look at Jameson and you look at Justice Tyson, who relied heavily on Jameson, that's what they're saying is jurors give meaning to the words they hear. They hear the word disclosed over and over again. That's what disclosure means. There's a factual basis. And if the witnesses keep saying there's a factual basis to the accuser's statements, then that's by definition would be a credibility. Again, sleight of hand vouching would be a credibility assessment.
Counsel, you can keep your own time, but you have 1 minute and
I know, I was just going to say, I have
seconds.
about a minute and a half left. If I could, I'll save a minute and a half.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court. My name is Hayward Earnhardt from North Carolina Department of Justice, appearing on behalf of the state. The victim in this case testified in court under direct and cross-examination that when she was 6 years old, the defendant sexually abused her 3 separate times. The jury listened to this testimony and, on proper instruction from the trial court, found the defendant guilty of 3 counts of taking indecent liberties with a child. Now on appeal, defendant contends that the jury's verdict was tainted by several fundamental errors in his trial, none of which he raised in the trial court. Accordingly, defendant can only obtain relief by showing plain error. The Court of Appeals below correctly determined that defendant failed to meet this demanding burden, which our appellate courts apply cautiously and only in the exceptional case. For two main reasons, the decision below should be affirmed. First, none of the witnesses in this case improperly vouched for the credibility of the victim, MC. Defendant concedes that none of these witnesses explicitly vouched for her credibility, and instead argues that their testimony indirectly conveyed to the jury an inference that amounted to improper vouching. However, none of these witnesses, implicitly or otherwise, expressed an opinion as to the credibility of MC or as to her allegations of abuse. Second, there was no error in the admission of the evidence of domestic violence under Rules 401 and 403, the Rules of Evidence. This evidence was relevant to explain the delay in the reporting of the abuse, and its probative value was not substantially outweighed by the danger of any unfair prejudice. And returning first to the question of improper vouching, and specifically—
Let me jump right in and ask you about that. How would you distinguish the case here from this court's decision from the situation in Tao?
In Tao, yes, Your Honor. Two main points. The vouching in Tao was a plain statement that sexual abuse occurred. The expert described a category of victims who in fact experienced sexual abuse but displayed no physical symptoms, and then explicitly placed the victim in that case in that category. Here, the defendant's argument is that testimony is not this plain statement of sexual abuse. It's done in this indirect manner that gives rise to an inference. It's simply put, it's not an expression of opinion that sexual abuse in fact occurred. And I also want to point out, unlike in Tao or any of those cases, here with the PTSD testimony, the trial court gave 3 separate limiting instructions. In these instructions, the trial court instructed the jury that this testimony was being admitted for the purposes of explaining the delay in reporting the abuse and for corroboration to the extent the jury found that it did corroborate MC's testimony. The trial court specifically instructed the jury that the evidence was not being admitted and they may not consider it to prove that any indecent liberties in fact occurred.
But you just said the court, we held that it was plain error in that case, correct?
That's correct, Your Honor.
Well, in this case, there's some testimony from Ms. Masola that, and I'm reading from page 15 of the state's brief, that quoted from her testimony that, quote, she's healing because she's had complex trauma. Doesn't that look like kind of a straight up statement that it occurred?
No, Your Honor. So the complex, sorry, go ahead.
No, just if you could explain why not, I'd appreciate that.
The discussion of the complex trauma started on cross-examination. Defendant elicited a statement that Masola had reportedly made to Crystal Pritchard of Winston-Salem Police Department to the effect that Masola thought most of the trauma was due to domestic violence. And then the defendant's attorney asked Ms. Masola whether you could tell which symptoms came from which trauma. She said no, she had complex trauma. And then so on redirect, the state simply pointed out that the fact that you can't tell which symptom came from which trauma does not discount the disclosure of sexual abuse. So in the context of the testimony, it's clear she was not expressing any opinion that any sexual abuse in fact occurred, or any traumatic event for that matter.
So to go back to Justice Hudson's question to you about distinguishing this case from Tao, is it then the state's argument that the only time we have inadmissible quote unquote vouching is if there is a direct, explicit statement, either in so many words or in a yes or no answer to a question, that the witness is telling the truth?
Your Honor, I think that's right. I think it has to be a plain statement, either that the witness is telling the truth or that sexual abuse in fact occurred, or a diagnosis of sexual abuse in the absence of physical evidence.
Is it your argument then that if the witness's answer does no more than permit the jury to draw an inference that the witness believes that the victim is telling the truth, that's not impermissible?
Well, Your Honor, the jury was not having to draw really any inferences in Tao. The jury wasn't having to do much work there. And so under the court decision in Tao, the vouching occurs when there's a plain statement that the victim was sexually abused, which is simply not what we have here. And defendant contends that the Ms. Mazzola chose to only discuss two types of trauma. But I want to point out that Ms. Mazzola specifically explained that in the course of her PTSD diagnosis and treatment, they don't go into every trauma that the child reports. They just ask what are the most traumatic experiences. And there was certainly evidence in this case of no shortage of traumas, to put it simply. Even in what they discussed in the PTSD treatment, there was multiple instances of domestic violence. There was also direct violence with defendant hitting MC. And then moreover, Ms. Mazzola also testified that MC was having issues due to the constant changes in placement, and that it was causing her therapy to take longer than they would have hoped. Ms. Mazzola also testified that one of the subsequent placements was an aunt who had struck her, which necessitated an additional change in placement. Another subsequent placement, an uncle, there was drug abuse, and MC testified that she did not feel safe, which necessitated an additional change in placement. And then on top of that, there's also the evidence that the entire reason MC went back to live with her mother in the first place was because her paternal grandmother had gotten cancer. And then when the MC went back to live with her mother, there was the evidence of, unfortunately, of drug abuse that MC observed in the home. And so, as I noted, there was no shortage of traumas in this child's life. To the extent that Ms. Mazzola's statement could be reasonably interpreted as a statement that MC in fact experienced traumas, certainly wasn't a statement that MC in fact experienced traumas based on an underlying event of sexual abuse that in fact occurred. And defendant pointed out.
What's your position on opposing counsel's position that although there may have been a number of traumas that were addressed by the expert, that the aspect of sexual abuse cannot be excised from that group of traumas in terms of the vouching component that the defendant represents?
Well, Your Honor, like I said, she wasn't referring to any specific trauma. So defendant's position is that it somehow amounted to a statement that sexual abuse specifically occurred, but you can't tie it specifically to any event. In fact, she said you couldn't specifically tie her trauma to any specific event. And then on top of that, as I noted earlier, even if the jury could conceivably pile together these inferences to interpret the testimony in that manner, the jury specifically instructed, or the trial court specifically instructed the jury not to consider the evidence in that fashion. That is, to prove that any indecent liberties in fact occurred. And I'd like to move, if there are no further questions about the issue of the Ms. Mazzola's testimony, I'd like to move for a moment to the question of the word disclose. And I want to start by saying there was certainly no plain error here in permitting the use of the word disclosure or some variation of it to refer to the reporting of the allegations of sexual abuse. The jury understood that this word did not convey a belief of the credibility of the underlying allegations. Rather, it simply referred to the reporting of the allegations of abuse that were not previously known, or at least not previously widely known. This is the manner that the state's attorney, yes, Your Honor.
Would help if I would unmute, sorry. I just want to ask you about the statement you just made. What's in the record that tells us that the jury understood that disclose was not suggestive that what was being disclosed actually happened? Where do we find that?
Your Honor, I think perhaps the most important aspect of that, or the part of the record that points most towards your question, would be the fact that defendant's trial attorney did use the word repeatedly in the same manner to refer to the reporting of the allegations of abuse. And I'll have to disagree with my colleague for the defense. By my count, there was at least somewhere around 11 times in front of the jury of use of the word disclose or some variation of it to refer to the reporting of the allegations of abuse. Now, this is defendant's trial attorney whose main function in the trial court essentially was to attack the credibility of the allegations of sexual abuse, and yet she repeatedly used that word to refer to those allegations during the course of the trial. So it does not seem realistic that the jury would have interpreted the defendant's attorney using it in the same manner as the state's attorney and the witnesses, as interpreting that word as conveying a belief in the credibility of the allegations. And I would also add that this word is, as you noted earlier, Justice Earls, this word is extremely common in this context, used in the same manner it was here. You'll see it in other trials as quoted in decisions that are cited in these briefs. It's also used by the courts themselves. For example, of the cases cited here, in O'Connor and Grover and Agualo, and then most recently in this court's decision in Warden in its statement of facts, uses it to refer to the reporting of the allegations of abuse in the same manner. And that's the decision where the, go ahead, Your Honor.
Well, to just follow up on that, if defendant had objected during the trial to the use of the word disclose, presumably the trial judge could have issued some kind of limiting instruction, caution to the jury, either, to not misinterpret the meaning of that word. I mean, is there any reason why that could not have happened?
Your Honor, that could have happened. Again, the state contends that the word does not contain any implication of credibility towards the underlying allegations. But yes, if the defendant had done that, that could have happened. But it's certainly not error to not give a limiting instruction in the absence of any request to do so, as this court explained in State versus Lawrence. And also with the defendant's argument with respect to the use of the word disclose, sort of a recent blip in this area. And if adopted, it would affect a substantial change in this area of law. Given how prevalent this word is, it would be difficult to untrain all the practitioners to stop use it. And it would certainly place the trial court and the trial judge in an unworkable position of basically having to sit there with the list of magic words and a hand on the buzzer waiting for an infraction. So I think it would make, at a minimum, it would make future cases in this context substantially and unnecessarily more complicated and more difficult.
Am I hearing in your argument that disclose, disclosure, and so forth has become a term of art when it comes to this area of the law?
That's possible, Your Honor. I think more in general, it's exceedingly common. I don't know that it's any different here than any other context, but at a minimum, in this context, it's certainly clear that the use of the word does not signal the belief in credibility that sexual abuse in fact occurred.
Opposing counsel on the other side says that this is not an everyday kind of word, and yet I hear you saying that the term disclosure in this kind of case would be hard to remove from the lexicon of this type of case. So I'm wondering, is it to be viewed by us as an everyday term, or should it be looked at as a term of art that has developed in the course of these kinds of cases coming about?
Well, respectfully, Your Honor, I don't know that people in everyday life are frequently referring to the reporting of allegations that haven't previously been made known. So I think perhaps it is an everyday word. It's just not something that would come up in everyday life. And in any event, I think certainly in this context, at least, if you want to call it a term of art or just something that has evolved to this point, it's clear when referring to allegations of abuse that it does not amount to an expression of opinion towards credibility or towards sexual abuse having in fact occurred. And with respect to the defendant's argument of waiver of the invited error argument, there's a couple points I want to make with respect to that. First of all, the defendant does not cite any authority that an appellee can waive invited error. But in any event, under the plain error standard of review, as this court explained in Lawrence, the court is required to examine the entire record. And also, the defendant's counsel's use of the word is not just relevant because it constitutes invited error. It's also, as discussed with Justice Earls earlier, it's extremely relevant to the understanding of the ordinary usage of this word. And next, I'd like to briefly address the issue of the evidence of domestic violence that was admitted. Defendant's argument regarding this evidence is solely under Rules 401 and 403 of the Rules of Evidence. There certainly was no plain error here by the trial court in admitting this testimony, given that it was relevant to explain the delay in the reporting of the abuse, which was a central question in this case. And also, given that the probative value was not substantially outweighed by the danger of any unfair prejudice. On that account, I want to point out that defendant's attorney elicited testimony regarding domestic violence of multiple witnesses, including MC, Mr. McSwain, Ms. Archie, and Ms. Mazzola, and then used the evidence regarding domestic violence in his closing argument to, as part of his defense and theory of the case, to explain why MC had a motivation to fabricate the allegations of sexual abuse. So any error there, again, would be invited error. And if there are no further questions from the court, I would simply respectfully ask that this court affirm the decision of the Court of Appeals below. Thank you.
Thank you, counsel. Rebuttal.
Yeah, just a couple quick points. In terms of Tao and the equivalence of this case, they're both the same. Tao, you need an inference. Tao, again, the jury has to listen and say, okay, 70-75% of abused children don't have this or don't present with these symptoms. And then the next question is, well, did the accuser in that case fall in that realm of cases? Yes. I mean, you have to make an inference, right? The expert is not saying explicitly it's vouching. So you need, all these cases deal with inferences. Most trials deal with inferences based on evidence presented by the state. Real quick about the disclosure claim. Yes, we could have a list of magic words, but that's what we do in pretrial litigation. If I did more trials, I could litigate this and say, you know, wouldn't make, I think the state was arguing that, oh my God, these trials would be so difficult to do. No, it wouldn't. You can simply have a pretrial hearing, make a motion, Your Honor, I would like to ensure that none of the state's witnesses use disclosed, and for this reason. That's what we do in Miranda. I mean, when Miranda was handed down, that was the argument it gave. Oh my God, what are we going to do? We have to retrain everybody. This is just a minor requirement in a small subset of cases. And with that, I think my time is up. So I appreciate everyone.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Welcome back.
Hey.